May I seek your Lordship indulgence in making a mention with Part 2, Item number 9, on behalf of my senior Joseph Lelsan Himarentle, who appears as the amicus in this matter.
Item 9.
Item number 9, Part
Okay.
2.
Yeah, when do you want it?
After a week, my Lord.
After a week.
Yes, my Lord.
Okay. List the matter after a week on the prayer of the Learned Council, MS such and such, on behalf of the amicus, Mr. Joseph such and such. Okay. So after a week. List after a week. Yes.
Daily list for motion, item 1.
May it please your Lordship.
Yes.
Your Lordships, this writ petition
Yes.
my lords, this writ petition is filed mainly, my lords, challenging the order at page 47. I'm sorry, page 49. Your Lordships has page 49.
Yes.
My lords, under section 127, what has happened is
Yes.
the petitioner's PAN jurisdiction that has been transferred from, my lords, the original jurisdiction, which is PCIT Shillong, Principal Commissioner of Income Tax Shillong, to Guwahati.
Okay. So where was it transferred? To
My lords,
Guwahati.
To Guwahati. And my lords, the IT department thereafter has taken certain steps against me which are prejudicial. I've annexed all those documents.
Was
This-
notice given to you before transferring?
Yes, my lords. If your lordships has the earlier page at, just the prior pages at page 47.
Yes.
This is dated 24th February, my lords.
24th.
February.
Yes.
It has been informed by the PCIT that a search and seizure operation under 132 of the IT Act was conducted in your case on so and so. In this regard, a proposal for centralization of UPAN has been received in this office in pursuance to the reasons cited in para 1 above. My lords, may skip para 3 and come to 4, my lords. I hereby propose to pass an order under 127 of the IT Act in your case. Your objection, if any, may be filed within 5 days.
5 days.
Now, my lords,
Okay.
the order,
You were given
Which-
5 days and then
5 days was not given to me. The very next date is the order which I have shown your lordships at page 49.
Okay, the notice was 24th and the order is 25th.
5th.
Okay, on the next day itself.
Yes. Now, my lords,
Yes.
the Act under 127 says there are 2 criteria, my lords.
Any provision for appeal under this?
No, my lords. We've said that in the petition also. And we can show in the, through the Act also, my lords. Your lordships has
Let's see.
page, section 246A.
246A.
Yes. Page 1001.
246A. Yes.
My lords, this is an exhaustive list.
246A, you said.
Yes, my lords. 246A. Appealable
Appeals
orders.
and revision.
Yes. Appealable orders before Commissioner appeals.
We appeal to the Joint Commissioner. Yes, against. There's a long list.
Yes, my lords. My lords, one thing is that the
This is an order under 127.
My lords, can I show judgment?
Okay, that's better. Anyway, notice has been served,
No, my lords, this is a fresh matter.
fresh.
Yes.
No, but you have the Central Government Council here, isn't it?
My lords, specifically for Department of Revenue, notice has to be
Okay.
sent. My lords, here in this, before the Honorable Supreme Court, similar issue had arisen, which your lordships would see from para 1. Leave granted. The challenge in the present appeal is against the order of the High Court of Madras, passed in CIT versus Nurul Islam, by which the transfer of the income tax assessment file of the appellant from Tamil Nadu to Kerala is made by the Jurisdictional Commission of Income Tax has been upheld. For the purposes of this appeal, it would be necessary to note that provisions of so and so. So, my lords, here also, before the petitioners had gone before the Honorable Supreme Court, it was a direct petition to the Honorable High Court because it's not an appealable order. And here, my lords, para 3 is important.
It's been transferred from one assessing officer to another. But in any case, notice, I think they said 5 days, but
Yes.
then very next day they have issued the order. So what is your prayer basically?
My lords, my prayer is
Quashing and setting aside the orders and such, staying the proceedings. Okay, issue notice.
my lords,
Yes, interim prayer.
yes, my lords, today, my lords, what is happening is there is two things which are happening, my lords. A penalty has been imposed upon me, my lords, which page I'll show. And my lord, simultaneously, despite the penalty being finalized without prejudice, they are summoning me all the way to Guwahati. I am a trader in Mizoram, my lords. Because of this jurisdictional change, everything has happened. Because of this, I would say illegal order passed on 25th February. Section 127 says two things, my lords. That I must,
Penalty has also been imposed
yes, my lord,
pursuant to this.
pursuant to this.
Let's see the order.
My lords, the order is at page 52. Your lordships can have the operative portion at page 66. Since the explanation of the SSE as submitted on so and so has already been held to be lacking in merits on facts and law, I come to this conclusion that this is a fit case for imposition of penalty under 271(a) of the Act. I also hold that the proviso to Section 271(a) is not applicable in the case of the SSE, as she has failed to prove that there was good and sufficient reasons for the contravention of provisions of Section 269 ST. As per the provisions of Section 271(a), if a person receives any sum in contravention of the provisions of Section 269 ST, he shall be liable to pay by way of penalty a sum equal to the amount of such receipt. In the present case, SSE received an aggregate amount of so and so in cash in contravention of provisions of Section 269 ST. Therefore, it is held that the SSE is liable to pay by way of penalty a sum of so and so. I hereby impose a penalty of this.
this is an application under Article 226 of the Constitution of India, praying for a direction, praying for quashing and setting aside of the impugned order dated 26/3/2025 with DIN number, you just see from the cost title, okay, DIN number such and such, dated 25/2/2025, along with the notices dated 24/2/2025 and 25/2/2025 with DIN number such and such and DIN number such and such respectively. Heard Learned Counsel for the petitioner, Mr. Jordan.
Rohingya.
Yeah. Stop. The case of the petitioner is that the respondents herein. Who are the respondents? All the respondents.
The order was issued by respondent number 3, so far as
Respondent number 3.
25/2.
Okay. Okay, so we'll just say respondent.
Respondents, my lords.
The respondents had issued the impugned order dated 25th February 2025 without giving any opportunity of hearing to the petitioner, as this is a notice. 24th
24th
is a notice.
Is a notice.
As the notice dated 24th February 2025 was issued to the petitioner, stating that the objection, if any, had to be filed within 5 days from the receipt of the notice. Stop. However, on the very next day, dated 25/2/2025, the order under Section 127 Clause 2 of the Income Tax Act was passed, transferring the PAN jurisdiction of the petitioner from ITO Silchar,
Yes, my lords.
from ITO Ward 1 Silchar to DCIT Central Circle -1 Guwahati. Stop. The contention of the petitioner is that thereafter another order dated 26/3/2025 was passed by the respondents, imposing penalty under Section 271(d)(a) of the Income Tax Act. Stop. It is also stated that the order under 127(a) of the Income Tax Act is not appealable in view of Section 246(a) of the Income Tax Act, and therefore the petitioner is before this court. Stop. Your impugned orders are that one, and then the penalty,
Yes.
imposition of the penalty. Yes.
And my lords, the summons which are being issued
And
by
the summons. So the petitioner has also contended that in pursuance of the impugned notice dated 25/2/2025, the respondents have issued summons to the petitioner. Where is it? The summons.
My lords, these are at pages 67 onwards. The latest is at page 79.
Have been issuing summons to the petitioner, the latest being page 79.
Yeah, 78, my lords, dated
78.
3rd July 25.
The latest being dated 3rd July 2025, vide DIN and notice number. You just read from here. Huh? This is page 78. Being under DIN and notice number such and such, dated 3/7/2025. The petitioner has therefore prayed for quashing and setting aside the impugned orders dated 25/2/2025, 26/3/2025, and the pursuant investigation proceedings and the notices and the summons issued under section 131 under bracket 1A carried on by the respondent number 8. Stop. Para. Issue notice returnable within 4 weeks.
The status quo may be maintained.
We'll see. Wait. The petitioner shall take steps for service on the respondents by registered post with AD as well as usual process within 3 working days from today. Stop. Till the next returnable date, the orders dated 25/2/2025, 26/3/2025, and the proceedings undertaken under the IT Act shall remain state. Okay, till the returnable date. Yes.
Grateful.
For admission, item 2.
Your Lordship,
Yes.
although I have received a counter affidavit in oppositions and additional affidavit from respondent number 4, so I would like to seek some other times to make a reply on affidavit in oppositions and the additional affidavit.
I think you were
Because-
supposed to file a rejoinder,
Oh yes,
Yes,
Your Lord-
yes.
yes, Your Honor.
not yet filed.
Yes, Your Lordship. So, Your Lordship,
Yes.
if I may seek some other times, because the petitioners, despite the road conditions from Labung, that is in Lunglei district, she's having some health issues, so she couldn't come to Aizawl to give her signature. So, if I may seek some other times, if the court insists, may this matter be listed after 2 weeks?
You have been taking time on several occasions, I think. 22/7 also, you were given some time
Yes, Your
to
Lordship.
file a rejoinder. How much more? 2 weeks?
2 weeks, if the
Okay,
court
2
insists.
weeks. MS Jacinta,
Lalian Pui Kian De.
such learned counsel for the petitioner, has prayed for some more time to file the rejoinder affidavit to the counter affidavit filed by respondent number 4. Stop. It is stated that the petitioner is unable to come to Aizawl to sign the affidavit because of bad road conditions. Stop. The petitioner is allowed another 2 weeks' time to file the rejoinder affidavit as prayed for. Learned counsel, such and such, appears for. You just put the names of the respondents, okay? Just give your names.
Respondent number 1 and 2, State Bank of India.
Respondent,
And I'm, Your Lordship, I'm for respondent number 4, state respondents.
state respondents, such and such.
Lordship, I'm appearing on behalf of my senior, who is the counsel for respondent number 5.
Respondent number 5. Yes, okay, after 2 weeks. Please, after 2 weeks.
Item 3.
May I please, Your Lordship?
Yes.
My Lord, this is revision petition against the impugned order which was passed in execution case before compliance of the order was executed, before the order was executed, my Lord. The respondents herein were, my Lord, the rival party is the respondent number 1.
Notice is complete.
Notice is complete, my Lord. So far as the respondent number 2 and 3 were concerned, state respondents, they were pro forma respondents.
Do we need to call for the records?
LCR has arrived, my Lord.
Yes, here it's come. Okay.
Only the order sheet may be, Your Lordship may like to peruse after some time. Only the order sheet.
Okay.
Earlier, my lord, I have filed one civil suit before the Lanka Trial Court, civil suit number 18 of 2017. Civil suit number 18 of 2017, wherein I have prayed inter alia for granting of permanent and mandatory injunction against the respondent number 1 herein, since they have disturbed us in our ongoing construction. I have constructed a house, and there is one step between my house and the respondent number 2 custom office. There is one custom office, and in between the custom office and my house, there is one step, and that is the common passage. But that step belongs to the land of the custom office. And after receiving no objection from the custom office, I have been utilizing this step, and I have constructed my house, and the construction, for the purpose of construction and for ingress and egress to my land and building, I have to utilize this step. And the respondent number 1 resided on below the custom office, and he is also using the same passage.
Respondent 2 is the
Respondent 2 is the custom,
and respondent 1 is the private
private respondent. The respondent number 1 resided below the custom office, and we all are using the same common step. And since the respondent number 1 has been disturbing us during construction, I have filed this civil suit number 18 of 2017. And this was disposed by the London Trial Court by judgment and order dated 11/2/2019, which is in page number 19 of my petition, Annexure 1, page number 19.
Yes.
And during the trial of the suit, the respondent number 1 had constructed steel hand railing on the side of my house, and that was removed during the pendency of the suit in pursuant to the injunction order.
What was removed?
Hand railing, steel hand railing.
Okay.
And my lord, if I may take a lordship to the operative portion of the judgment and order in the civil suit, page number 30, running page number 30.
Yes.
Para 27, my lord. From Para 27, may I read?
Yes.
The suit is decreed upon contest in favor of the plaintiff and against the defendant. Therefore, it is ordered and decreed that the defendant, Mr. Zokaliana, who is the respondent number 1 herein, has no right to interfere or object the plaintiff from peacefully using the steps, which is also called the public steps, which is included in the land list of the pro forma defendant, custom, to ingress and egress to the land of the plaintiff covered under LSC number such and such. Para 28, my lord.
Yes, please read.
Para 28. By way of permanent and mandatory injunction, the defendant, Mr. Zokaliana, respondent number 1, is hereby restrained from interfering with the peaceful enjoyment of the steps by the plaintiff and her man for the purpose of ingress and egress to her land covered under LSC number such and such, and also for any construction purpose. Prepare degree accordingly. Thereafter, my lord, they have preferred an appeal before this honorable court, but that was dismissed. I have enclosed the...
You have enclosed?
Yes, my lord. Page 32. Page 32, Annexure 2. Dismiss. This is IA civil number 81/2021. This IA is in respect of condonation of delay, seeking delay, condonation of 874 days. And this honorable court by order dated 24/2/2022, page 34. The IA was dismissed. Delay was not condoned. And accordingly, my lord, page number 42. Page number 42. Have you got it, my lord? Page number 42. In view of the order passing such and such,
Okay,
the
please.
RFA was also
So
dismissed.
without going into merit on condonation, it was dismissed.
Yes, my lord. And thereafter, they have not preferred any further appeal or review whatever. So the order of the London Trial Court had attained its finality. But thereafter, my lord, my grievance is that, my lord, after all this civil suit and the RFA filed by the respondent number 1 was dismissed, the respondent number 1, in spite of passing the permanent and mandatory injunction had again constructed the steel hand railing on the same place, and for which I have filed execution case number 76 of 2023. And during my lord, if your lordship may kindly see page number 43.
The photos.
Yes, my lord. From A and B, my house is on the left side, and the right side blue building is custom office, and the house of the respondent number 1 is on the down below, on the end. And this, as you can see from the photo, my lord, this photograph, my lord, they have cut some portion, no doubt, maybe 2 feet to some level. But if you look at mechanism, column D, photograph D, this portion is entirely blocked. And my construction is going on, my lord. And the learned trial court in the civil suit had restrained the respondent number 1 by way of permanent and mandatory injunction. And while the execution case was pending, my lord, before the land trial court, the learned trial court, the executing court had passed the impugn order. And if I may take a lordship to the impugn order, my lord, it's in the, after the,
Page 44.
page 53, my lord, 53. This has been passed in the absence of the plaintiff's counsel and without verifying the submission made by the counsel for the JD, judgment debtor. Impugn order dated 16/8/2024. Learned counsel for the parties are present. Execution petition number 76/2023 is taken up today. From the photographic evidence which is shown before the court, it appears apparent that the step railing which the degree holder alleged that had hindered the construction has now been removed to the extent that there is a right of way as dated by the judgment order dated such and such. Consequently, this court finds no need to interfere further by way of execution in the civil suit pursuant to the judgment order dated such and such. The execution petition stands disposed of. My lord, this purported photographic evidence recorded in the orders, impugn order, my lord, I have checked the records, I have checked the LCR. There are no such photographs submitted or placed on record before the executing court. Perhaps it may have been shown from the mobile phone picture. And moreover, my lord, this contention was not even verified by the executing court, and neither the petitioners were given an opportunity to rebut this contention. And the photograph which I have enclosed in my petition, my lord, this is the recent photograph.
When was this taken? Before the execution order or after?
After, my lord, just before filing this petition, my lord, my revision petition.
Your house is the left side, is
my
on the
lord.
left side.
My lord, this photograph was taken on 5th of November 2024, and the impugn order was passed on August 2024.
And the defendant's house is this blue one?
No, my lord, this
blue
is the
one on the
custom
right
building.
side.
Blue one is the custom building.
Oh, okay, okay.
It's below.
Defendant's house is below
It's
that.
behind below this blue building, the defendant number 1 house. The manner in which they have acted upon, my lord, in constructing this railing is contemptuous in nature, my lord. And unless this honorable court interfere with the impugn order, my lord, I'll have to approach the court again on the same course of action. And the judgment order which was rendered by the land trial court would become futile, my lord. So my humble prayer these days is that, my lord, let the impugn order be interfered with, set aside, and let the matter be remanded back to the executing court for proper adjudication for the interest of justice. That will not prejudice the respondents also, my lord.
Actually, spot verification should have been taken.
Exactly, my lord.
Yes, who's appearing for the...
My lord, I'm appearing for the respondent number 1.
Respondent 1.
So basically, my contention is that the executing court has rightly exercised its jurisdiction in this regard, because, my lord, this petition actually pertains only to the actions of the petitioner, to show who is might and a domineering action in this, as to who could be dominant in the process of law. My lord,
No, but the photographs which are enclosed here, you've seen.
I have
so
seen,
the
my lord.
railings, it's
Lordship may see
it's covering his entry into the building, isn't it?
No, my lord. Lordship may kindly see page 49 of the petition, the photographs. And page 50 as well. It has been cut, my lord. Has been removed and trimmed.
But how can this court at this stage, unless the executing court does spot verification, we cannot say, because the photographs you have given and the photographs which the petitioner has given, they are different.
Correct.
They are different.
But, my lord, this is the written objection filed in the execution in the execution court, and that was filed on 1st of February 2024. The order was passed on 16/8/2024. 6 months, my lord. There was ample time for re-verification if at all the petitioners were actually
16/8/24.
vigilant in this case. And, my lord,
Your impugn order was passed on 16/8.
16/8, my lord.
16/8/24. So what took you so much time?
My
When
lord,
did you file this?
kindly see the LCR order sheet, my lord. All the adjournments have been made on behalf of the defendants. The first order was passed on 22nd June 2023. And thereafter, notice was issued on 21/7/2023.
21.
Judgment debtor are absent. And on 29/8, fresh summons was issued to the judgment debtor. And on 29, for appearance in WO, none appeared. And 11/10, 16/11, 13/12, same order, 4WO in order. 23/1, 4WO, no objection was there. And from 1/2/6/3, for hearing. And it simply stated that for further proceeding, JD is absent. And in fact, what happened in the trial court, my lord, they have keep on changing the counsel again and again when they are standing on the loose soil. And on the day of the impugn order, my lord, the learned executing court abruptly passed the impugn order without verifying the submission of the respondent, my lord.
No, it says learned counsels for the parties are present. 16/8/24.
Yes, my lord.
The
But
order sheet.
the documents which the land trial court is relying upon, my lord, that has not been verified, and no chance was given to the
From the photographic
degree holders.
evidence.
And apparently, at present, my lord, there is still
No, the photographic evidence, was it produced on that day only? It was not given to you.
no, my lord, and that is not even available in the LCR, my lord. And under any circumstances, my lord, what appears from here is that there is still this railing is still in existence.
Okay, we'll remand it back, okay, and dispose it. I think it was not done properly. The executing court has not handled it
Lord, may
properly.
kindly record my submission, and I have an authority, if my lord may allow me to cite the citation, because the scope is very limited in revision petition. If that's not
No,
required,
that's true, but if there is any illegality or irregularity, then this court has to interfere, isn't it? Yes. Chamber disposal, okay?
Deeply obliged.
Yes. Yes.
Item 4.
Just send it to my chamber. Yeah. Yes.
May it please your lordship. AD card from respondent number 7 has not been returned, my lord.
Respondent number?
7, newly
7.
included 7.
My lord, I will be representing respondent number 2.
Respondent to
Yes, my lord.
learned counsel for the petitioner is present. Stop. Learned counsel such and such has entered appearance for respondent number 2.
My lord, if I may be given a week's time to...
Yes, and prays for a week's time to file her affidavit in opposition. So, the office note indicates that the the service on respondents, the service on the rest of the respondents is still awaited. So, you want to take fresh steps or will wait?
It's better if we wait, my lord. It
Okay.
has not been that long.
Accordingly, list the matter after 3 weeks, awaiting service report on the rest of the respondents, and the learned counsel for the respondent number 2 is also allowed to file the affidavit in opposition in the meantime. Yes, list of the 3 weeks.
Item 5.
Yes.
My lord, today is listed for the admission hearing actually.
Notice is complete.
Complete. Pleading is complete.
Yes.
Yes. May I proceed with the brief?
Yes.
Thanks, my lord. Back in 2009, my land located in Pang Khua and Sangao village in the Long Klai district was taken by the respondent for the construction of the defense road without resorting to the procedure established by law.
Okay.
And my submission here is that, my lord, the notification which was
For construction of road.
yes, notification which was mandated by the section 3 of the LA Act of 1894 has not been issued by the respondent. So thereafter, back in the year 2015, I approached this honorable court by wide writ petition number 53, and that writ petition was disposed of by this court, directing the respondent to conduct spot verification and acquire the land and the release compensation as per the findings and the outcomes of the spot verification, as well as after examination of the nature of my passes of my land records.
That was done.
That is done, and in pursuance to that notice,
the spot verification was conducted and completed on 3/8/2016, wherein that spot verification clearly indicated my land has been damaged by the respondent. However, despite however, the spot verification has been completed, the respondent has not proceed any further, and they have not acted as required by the law that was enforced at the time of that possession
That
of
means
my land.
you are saying that assessment, payment of compensation has
No.
not been done.
No, my lord. The respondent stopped their process only in the verification. Thereafter, nothing has been.
Yes, state respondents. You filed counter. Yes. Are you denying?
We have enclosed the annexures. We have enclosed the joint verification report. It's not denied, madam, that the lands has been encroached.
Mention may be made that verification was conducted. Okay, so verification was conducted in 2016,
Yes, my lord.
3/8/2016, and thereafter, what have you done?
My lord, actually they have filed a writ petition 56 of 2015, which is at page 46 of the writ petition. Here, my lord, there are 38 petitioners, and the direction of this honorable court was to conduct spot verification and to see that whether they are entitled or not.
Yes.
My lord, after this joint inspection report, we have found that only this number of persons, 8 persons were eligible
Entitled.
for that. Yes. So thereafter, my lord, no fresh steps have been taken.
Because see, the court's order says,
Yes.
in the event it is found that petitioners' passes are valid and that they are entitled to compensation, the respondents are directed to acquire the lands and pay the compensation
Yes.
as per the land acquisition law applicable. So those who are not entitled, that is, the court is not saying to pay the ones who are not entitled, but for the ones who are entitled, you have to pay, isn't it?
Yes, ma'am. I think there has been some misunderstanding because in this writ petition, there are many petitioners who are not entitled. So after the spot verification, only 8 persons were entitled. That is why there was
Only
some
8
confusion.
persons.
Yes.
Have you specified in your affidavit like those who are the 8 persons?
My lord, in the joint inspection report, my lord, at page
Okay,
6
okay,
of my
yes.
affidavit.
So out of this,
And the problem is, my lord, we'll see that at serial number 1 there is F. Rohunga, and he has withdrawn from the petition. So there has been some,
withdrawn from the petition means the earlier petition or this petition?
I think it's the earlier petition.
Earlier petition. So have you seen this,
Yes, my lord.
the verification report?
Yes, my lord.
So in view of this, only some of you are entitled,
Yes.
not everyone.
Not everyone, my lord.
Yes,
The 8 petitions.
yes. So one has also withdrawn,
Yeah,
serial number 1.
he was withdrawn.
Then 2 excluded, rejected.
Oh.
3 absent. 4 no damage.
My lord, let's see the serial number 6. Serial number 6.
Yes, serial
7.
number 6.
7,
6, 7,
15,
15,
19,
7, 15, 19,
and 21 in the next page.
21.
Yeah,
21,
24,
24,
25,
25, and
and
38, 34.
34.
So they also petitioners here?
Yes.
Okay. So you pay them, those who are entitled?
Yes, Your Lordship.
Yes.
If it's the order of the court, will pay them.
Because the earlier order is already there and there is no appeal against that.
Yes.
So that has attained finality, isn't it? This rate petition 56. So can we dispose it off, or you want to take some
My Lord, I
instructions?
think there are some confusions regarding that, my Lord. In the joint inspection report, this Union of India are absent again. So
My lord, in that regards, in the affidavit in opposition,
Are they a party here? No.
they are the parties here, yeah.
yes, Your Lordship.
And
Central
in the
government, yes.
affidavit in opposition submitted by the respondent, 3, 5, and 6. And you may please see, my lord, page number 11. And the respondent has clarified that their involvement is limited.
Excuse me?
Yeah,
Yes.
the involvement of the BRO official is limited to the
Limited.
joint survey. Yeah, to the joint survey only. And so the spot verification actually it's under the authority of the
State
Gala.
government.
Yeah, the respondent.
No, if you want to take some further instructions, it's okay. We can list it after a week. Is that
Because, my lord, the respondent has already clarified it.
no,
My
they
Lord,
are
I think
not
the
the-
Union of India has something to say in this regard.
that's why, that's why.
My Lord, the petition already filed WPC 56 2015.
Yes.
Then they approached it again, this Honorable Court, for not compliance with that court order. However, instead of filing a contempt petition, they come again with writ petition. That is why it's not maintainable. Anyway, then in the earlier writ petition, the name implemented as a Union of India is not the concerned department. In the meantime, we are not a member at the time of joint verification that already conducted. That is why we cannot accept that joint verification conducted without the BRO, my Lord, because we are not a party in that earlier writ petition. Even
In
the name of
WPC
BRO is
56.
mentioned, but that was not the concerned department. We are not called.
In WP 56 or 15, you were not party.
Even BRO is a party, however, the concerned department is not a party because we are not aware of that writ petition. In the meantime, the writ
Concerned
petition,
department means which department would that be?
in that earlier WPC,
Here in WPC 56, the Ministry of Transport is there, Ministry of Road Transport and Highway, then the DG Border Road is there, Superintending Engineer, Ministry of Road Transport and Highway is there, then Commanding
Yes, my lord.
Officer Road Construction is there, GREF.
in the present case, we are respondent correctly. However, in the earlier writ petition, we are not a party. At page 46, my Lord,
At page 46,
of the
that's
writ
right.
petition, of the writ
I'm
petition.
looking at the respondent list at page 46. So there, GREF is there, so you're saying that the Director General Border Road should have been a party.
Here, in the present writ petition, the concerned department is there.
Which one? Superintending Engineer Regional Office, this one?
71 RCC Construction Company is the concerned department.
Officer Commanding 71 Road Construction, this one?
Yes, my lord.
Grave. No, but you see respondent number 5 in WP 56, respondent number 5, isn't
My
this
lord,
the same?
the 72 construction is not there within Mizoram.
Oh, cha. It should have been 71.
Yes, my lord. That is why we are not a party at the spot verification team.
Oh. That means earlier you did not contest?
Yes, my lord. In the meantime, the writ petition has been disposed of at motion stage.
Motion stage?
Yes.
Oh, I see. But now in this petition, 71 they have
Yes, my
completed.
lord. Because as prayed by the counsel for the petitioner claimed based on that verification, where we are not a party.
Oh, then in that case, I think fresh verification
Yes,
will
my
have to
lord.
be done.
It may be better.
Because in the last writ petition, proper party has not been implemented.
But my lord, they are the same entity. They belongs to the same entity.
No. This is 71. Earlier you have put 72.
The 72 is located outside Mizoram. my lord.
So each, for them, for Army and Grave, each company is different. They are located in different places, stationed at different places. Okay, then we'll dispose with the direction for fresh verification
my
then
lord.
in that case. Lord Learned Counsel for the petitioner, Sri such and such, as well as Learned Additional Advocate General, Miss Linda and such, and the Learned CGC, such and such. Stop. Para. The present writ petition has been filed by the petitioners seeking for a direction to the respondents to quantify the payable amount of compensation and release the same for acquisition of their land for construction of road along Tingsai-Baul Pui, you just see from the petition, okay, with a length of 56 kilometers in the year 2009 by the petitioners. Stop. Para. It is contended by the petitioners that in the year 2015, they had preferred a writ petition being WPC 56 of 2015 before this court, and the same was disposed of by order dated 2/12/2015. Stop. By the order dated 2/12/2015, this court had directed the respondents to examine whether the petitioner's land passes have been issued prior to the construction of the road and in 2009, and also to examine whether the landowners are entitled to the right of use of the land. Stop. The direction had been given to the Deputy Commissioner / District Collector to verify the same, and if the petitioner's passes were found to be valid and that they are entitled to compensation due to construction of roads over their lands, comma, the respondents were directed to acquire the lands of the petitioners and to pay the compensation as per the land acquisition law applicable. Stop. It was also directed that the entire exercise would be carried out within a period of 6 months from the date of receipt of the order. Stop. Para. The petitioner submits that despite these findings and despite a joint inspection report, a joint spot verification which was conducted on 3/8/2006, assessing the damages caused on the landed properties of the petitioners, comma, no compensation has been paid to the petitioners for over a decade and a half. Stop. It is stated that the petitioners have submitted several representations to the respondents in respect of the payment of compensation and for compliance with the order dated 2/12/2015 passed in WPC 56 of 2015. Stop. However, no action has been taken by the respondents till date. Stop. Being aggrieved, the petitioners have approached this court. Stop. Para. Learned Additional Advocate General such and such has submitted on the basis of the affidavit in opposition filed by the state respondents and submits that the spot verification had been conducted on 3/8/2016 and the verification report has been annexed in the affidavit in opposition. Stop. According to the spot verification report, only 8 persons from amongst the petitioners have been found to be eligible and entitled for the compensation. Stop. However, Learned Additional Advocate General has stated that the respondent number 6 herein, which is the 71 Road Construction COY, COY, okay, GREF in brackets, PIN 930072, care of 99 APO, had not been made a party in WPC 56 of 2015, and therefore during the spot verification they were not present. They were not present. Stop. Accordingly, she has prayed that a fresh verification may be required in the present case. Stop. Learned CGC, such and such, has also made a similar submission and has stated that the 71 Road Construction COY GREF such and such was not a party in WPC 56 of 2015, and as the petition was disposed at the motion stage, they were also not aware about the disposal of WPC 56 of 2015. Stop. Moreover, the 71 Road Construction COY GREF, which is present in the state of Mizoram, was not a party in the joint verification, which was conducted on 3/8/2016. Stop. Para. considering the facts and circumstances, comma, and the fact that the 71 road construction Koi Gref care of 99 APO was never made a party in the WPC 56 of 2015, comma, which is also not disputed by the counsel for the petitioner, comma, the present petition is disposed of with the direction to the Deputy Commissioner is a party here, to the respondent number 8, to the respondent number 8 / Deputy Commissioner Lot Lai District, Mizoram, to have a fresh spot verification in the presence of all the parties and to arrive at the decision as to which petitioners are entitled to payment of compensation for acquisition due to the road constructed over their lands. Stop. The entire exercise shall be carried out within a period of 6 months, will do, 6 months from the date of this order. So, next paragraph, the petition stands disposed with the above directions. Yes.
Item 6.
My Lord, service is completed and the respondent number 1 and 2 are represented by the Legal Aid Council.
My Lord, I have been appointed as a Legal Aid Counsel for respondent 1 and 2.
1 and 2.
Yes, my Lord.
So, will you be filing any objection?
I have not yet received the
you have
petition.
not received a copy.
My Lord, I will give a sharp
You
copy.
can
my
give
Lord.
during
Extra
the course
copy.
of the day? You can give today
yes, my Lord.
itself? Okay.
My Lord, I have a small prayer, my Lord.
Yes.
So, since the Lok Adalat Award, which is being under challenge, dated 14/9/2024, so the respondent number 1 herein constructing his building within a portion of his land, my land. So, my Lord, Your Lordship may be pleased to stay the Lok Adalat Award.
My
It's
Lord,
okay, yeah.
I
think it's,
have no idea about
yes,
this.
they don't even have the petition. So we'll give a short date,
My Lord.
and the interim can be considered on the next date.
My Lord.
Interim. But have you made any interim prayer in your petition?
Yes, my Lord. Interim prayer at page number 8, my Lord.
The construction is going on.
Yes, my Lord.
Then in that case, I think we'll have to do something. Otherwise, it may become infructuous, no?
Yes, my Lord.
Yes, learned counsel for the petitioner, such and such present. Stop. Ms. Emily L. such and such has been appointed as the legal aid counsel to represent the respondent number 1 and 2. Stop. The learned counsel for the petitioner shall supply copy of the petition to the learned counsel for the respondent 1 and 2 during the course of the day. Stop. And thereafter list the matter after 3 weeks. Stop. In the interim, the operation of the Lok Adalat Award dated 14/9/2024 shall remain state till the next returnable date. Yes.
Highly obliged.
Item 7.
My Lord, I'm here on behalf of Miss Mary L. Kiangte, who is representing respondent number 1 to 5. My Lord, she's indisposed today, but instruction is still awaited from the department So if this matter may be taken up after 2 weeks.
Okay. She's appearing for all the respondents.
1 to 5, yes, my lord.
1 to 5. Okay. Heard MS such and such, who submits, who has made a mention on behalf of MS Mary L. Kente, who is appearing for respondents number 1 to 5. Stop. She has prayed for another, how much time?
2 weeks time. my
Another
lord.
2 weeks' time to receive instructions and to file affidavit in opposition. Stop. Learned counsel for the petitioner is present. Stop. List the matter after 2 weeks.
Obliged.
And what about the other respondents?
There are 5 of them.
Oh, only 5 of them.
Item 8.
Lordship, as per the office note, the ID card or receipt has not been yet returned from the respondents 1 and 2.
Learned counsel for the appellant. Sri such and such is present. Stop. The office note dated 25/7/2025 indicates that the AD cards have not yet returned from the respondents till date. Stop. Accordingly, list the matter after 3 weeks awaiting service on
Yes, my lord,
respondents.
if the registry be kindly directed to do postal checking, my lord. Because it is 2 months since we have taken steps by way of Talabana.
Or you take first steps then.
All right, my lord.
Okay, awaiting service report now on the respondents. So the registry is also directed to track the was it sent by registered post?
Yes, my lord, by way of
To
Talabana.
track the registered post and submit the report thereafter. Yes.
Item 9.
May I please, your lordship? My lord, I have taken steps upon the respondents on 4th of August, and AD card has not yet returned, and we may await for service report.
Okay. Respondents 1 to 5, na?
Yes, my lord.
Learned counsel for the petitioner, Mr. Sen such present. Stop. The office note dated 25/8/2025 indicates that neither AD card nor service report has returned back in respect of respondents number 1 to 5. Accordingly, list the matter after 3 weeks awaiting service report on the respondents.
Will be obliged.
Item 10.
Lordship, this is the MAC appeal, and there are as many as 3 respondents in this case, Lordship. Then respondents number 3 is duly represented by my learned friend. And upon the respondents number 1 and 2, we have already served notice through the dusty mode.
Okay.
And as per the last court order dated 3/7/2025, and this Honorable Court 3/7/2025, Lordship, notice is deemed to complete upon the respondents number 1 and 2. However, Lordship, this Honorable Court observed that it may be proper to wait for the respondents number 1 and 2 to be represented, Lordship, since the respondent number 1 is the claimant before the learned tribunal.
Right.
So, Lordship, we have waiting the respondents number 1 and 2 long enough, Lordship. So till today, they are not represented. So
Did they appear before the tribunal?
they are appear before the tribunal, Lordship, because respondent number 1 is the claimant.
Oh, okay. And 2?
2 is they claim to be the owner of the accident vehicle, and the respondent number 3 is the counter claimant. And Your Lordship, my prayer is in the next court date, if they are not represented, then we may heard the matter without their presence also.
Okay.
And the notice has been duly served to them, and they have put their signature
Let us see.
Yes, Your Lordship. Affidavit 4, service upon the respondents number 1 and 2, which was submitted on 7/2/2025. 7/2/2025.
7/2/2025.
Yes. Page 8, Your Lordship.
1 minute.
Page 8 and 9.
When have you filed?
Filed on 7/2/20.
1/7.
Let's see. Yes.
One-
I have filed on
1/7.
First, yes,
Yes.
1st July 2025.
Page 10.
Page 10.
Yes. Okay, so the serial number 1 is respondent 1. Serial,
Lordship, yes.
serial number 2.
And we have found out that, Your Lordship, the respondent number 1 and 2 are the same person.
Then let's do one thing. We'll list it after 2 weeks.
Lordship,
And
yes.
we'll say that if they don't appear, we will take it up.
Lordship, yes.
Learned counsel for the appellant, Mr. Johnny, I think is present. Respondent number 3
My lord.
is represented by learned counsel. and
Tila
such.
Zekima, my lord.
Yes. Regarding respondent number 1 and 2, the appellant had taken steps by dusty mode and has filed an affidavit in compliance on 1/7/2025. In the said affidavit, it is seen that the notices had been duly served on the respondents number 1 and 2. Stop. However, when the matter is called, none appears for the respondent number 1 and 2 today. Stop. List the matter after 3 weeks. Stop. On the next date, if the respondents number 1 and 2 fail to appear, the IA shall be taken up in their absence. Stop. The IA shall be taken up for hearing in their absence. Yes. Do you have any objections? You can file.
I've already filed, my lord.
You have filed? Yes. This is IA 14. Okay. Yes.
Item 11.
Lordship, similar order may be passed. These are the analogous cases.
Here also. Okay. Similar order in IA 15. Here also you have filed compliance affidavit.
Yes, Lordship.
Item 12.
My lord, in this case, I was appointed as an amicus. I'm yet to receive the paper book.
Paper book is ready, otherwise. Learned counsel, Mr. C. Larfakzuala is as the amicus curiae has appeared before this court on behalf of the appellant. Stop. Learned PP, such and such is present. Stop. The paper book is ready. Stop. Accordingly, the registry shall supply copies of the same to the parties, to the learned counsels for the parties, and thereafter lists the matter for hearing in usual course.
Usual course.
In usual course.
Obliged.
Item 30.
May it please your lordship.
Yes.
My lord, I have the instant IA is for condemnation of a delay in filing the connected appeal. There is a delay of 1,782 days, my lord. My lord, we have impugned the order dated 20/07/2018 that is passed in airship certificate case number 868 of 2018. My lord, the reason for delay is that we
will issue notice.
My lord.
How come 1,700? Anyway, yes. This present application under Section 5 of the Limitation Act. You should have some very, very good reasons. Application under Section 5 of the Limitation Act has been filed, praying for condonation of 1,782 days. In filing this, the connected regular first appeal against the order dated 27/2018, passed in Airship Certificate Case number 147 of 2018. Stop. Issue notice to the respondent, returnable within 4 weeks. Stop. The Learned Counsel for the appellant shall take steps for service on the respondent by registered post as well as usual process within 3 working days from today. List of the 4 weeks. Yes.
And my lord, if I may be allowed to make one clerical
rectification.
Yes, my lord. In the course title, at page number 1, I have inadvertently written the number 147 of 2018, which should have been Airship Certificate Case number 868, my lord. So if I may be allowed to make this rectification.
Okay, the certificate case number.
Yes, my lord.
Stop. Learned Counsel for the applicant/appellant has also submitted that there is a clerical error in the cause title regarding the number of the airship certificate case, and he has prayed for allowing the rectification from 147 of 2018 to
868 of 2018.
860 of 2018. Stop. The prayer is allowed. The petitioner, the applicant/appellant shall make the correction in the cause title accordingly. Yes, you correct
Deeply
it.
obliged.
Item 14.
My lord, this I is for condonation of 156 days. In filing an appeal against judgment and order dated 17/12/2024. This is the first time the case.
First time.
Yes.
Coming up. Okay.
Notice may be issued.
Okay. Same order, application under Section 5 of the Indian Limitation Act. Condonation delay is 156 days in filing an appeal against the impugned judgment and order, judgment and award dated 17/12/2024, passed by the Learned Additional District Judge Aizol, Judicial District, Kolasib, Mizoram, in LA case number 32 of 2015. Stop. Then usual notices, returnable within 4 weeks. The counsel for the petitioner shall take steps by registered posts as well as usual process within 3 working days from today, and list after 4 weeks.
Item 15.
In this item, my lord, there is a delay of 255 days.
Okay, same order. Then here delay will be 255
and judgment and order is different.
55 days, and then judgment and order will be
10/9/24.
or judgment and order dated 10/9/2024, passed by the Learned Judge Fast Track Court, Kolasib District, Kolasib in LA case number 1 of 2022. Here is
If you
issue
lodge it-
notice, returnable within 4 weeks. Notice on respondents by registered post with AD within 3 days. No?
If your lordship may kindly correct the previous order. The previous order was passed by Fast Track Court also. Fast Track Court, Kolasib.
The last case.
Yes, item number 14.
Okay, that also fast track court.
Fast Track Court.
You just go through the record and see, no?
Right.
Yeah. I don't know if we start now. See, the problem is now we have 2 hearing matters, part 2 matters. And again at 2, we are going to take up the supplementary list of the other court.
Yes.
So will it be feasible? I mean, if we start now, will we be able to complete? That is the question. Are parties ready?
Are the parties are parties. My lord, I have
Or
not
maybe
seen-
hearing matters we can take up another day.
I think the parties who are want to have a hearing, I'm not here in the court right now.
Okay. Then can we pass it over? Okay, okay. You are there in one of the cases.
But, my lord, since your lordship has expressed some difficulty for today, as the list for call number 1 will be taken up by
Yes,
this court
yes.
again. This may be taken up on some other day.
That is why. When do you want? Next week?
Yes, my lord.
Next week?
Your Lordship, if this matter may be listed after 2 weeks.
After 3 weeks?
Yes, Your Lordship.
Okay, just give the item number. Item 3. Okay, after 3 weeks, okay? In the prayer of the learned counsels with the parties. Then the other one,
Also,
parties
Your
are not
Lordship,
here.
item 4. Item 4.
Item 4.
It will be taken up next week.
Next week. Okay, item 4, next week.
My lord, if you may please allow me to mention part 2, item number 8. The matter to be listed on Thursday, 28 August.
Item 8.
Yes, ma'am.
On Thursday, we already have 2 hearing items. Not possible. Friday?
Friday is fine.
Okay, Friday, huh? Item 8, no? Yes. Item 8 hearing on Friday. Yes. And the other list will take up at 2.
Supplementary list for admission, item 16.
Yes.
If the state is still to file the affidavit, respondent 1 and 2 have filed the affidavits. Respondent number 3
Yet to file.
yet to file.
1 and 2 has filed.
1 and 2 have filed.
Yes.
3 is yet to file.
Yes.
Your
Will you
Lordship,
be filing?
Yes, Your Lordship. If 2 weeks time may be given, Your Lordship, I have personally gone to the department also and I've reminded them to draft the affidavit. They're drafting it, it's in the process. So once it's vetted, Your Lordship, I will be able to file the affidavit.
Pension, this is a matter
In
of
fact, Your
pension.
Lordship, I mean, a number of opportunities have been already given. So if this can be a last chance. The petitioners
It's a
have
matter
not-
of pension, so
Yes.
it needs expeditious disposal. Last chance? 2 weeks. Okay. Learned counsel for the petitioner, Mr. Almin Malhotra is present. Stop. Also, we are learned counsel for respondent number 1 and 2, MS such and such, and learned government advocate, MS such and such. The learned government advocate appearing for the respondent number 3 has prayed for further time of 2 weeks to file the affidavit in opposition on behalf of, who is respondent 3?
State.
Oh, okay, on behalf of the respondent number 3 / state respondents. Stop. From the various orders passed by this court, it appears that the state respondents have taken adjournment several times in order to file the affidavit in opposition. Stop. As this is a matter of pension as a matter of pension payment to the petitioner, the state respondent / respondent number 3 is allowed another 2 weeks time as a last chance to file their affidavit in opposition. Stop. Yes.
Item 17. Item 17.
Yes, item 17.
Similar order.
Similar order.
Similar order. Okay.
Okay. No affidavit
No affidavit.
by respondent. Here also respondent 3?
Yes.
Okay. Similar order, 2 weeks time for respondent 3.
Item 18.
Yes.
My Lord, this can be taken up for disposal, my Lord. If after this part 1 item, my Lord, let the matter be followed.
It's a covered case.
Yes, my Lord.
Covered case.
Yes, Your Lordship.
We can have it after some time, after finishing
Okay,
the part.
okay. After the other matters. Yes.
Item 19.
CGC. No counter.
My Lord, I am for the respondent number 1 to 5. I'm
Yes.
seeking another 3 weeks time for filing my
3
affidavit.
weeks. Lord Learned Counsel for the petitioner, I may such and
My
such.
Lord, may
Stop.
this be the last chance?
No, my Lord. We just completed, my Lord.
Just completed. When? Anyway, it's a union, so they require something. Learned Counsel for the petitioner, no? MS such and such. The affidavit in opposition in respect of respondent number 1 to 5 has been filed. Stop. Learned CGC, MS such and such, prays for how much time?
My Lord, 3 weeks may be given.
3 weeks time to file their affidavit in opposition as they have been completed only recently. Stop. Accordingly, the Learned CGC / which respondent?
Respondent number 6.
Respondent 6 is granted 3 weeks to file their affidavit in opposition. So at least after 3 weeks. Yes.
Item 20.
My Lord, similar prayer in this matter also.
Similar. Same order, Learned CGC, 3 weeks time to file their affidavit. Here also respondent 3. Respondent 6. Here also respondent number
I am for respondent number 6.
6 here also.
Your Lordship, for respondent number 1 to 5, state respondent.
Filed.
If 3 weeks time may be granted, Your Lordship.
Oh, state respondents also have not filed.
Yes, Your Lordship.
No, I think 1 to 5 is already there. Affidavit in opposition on behalf of state respondents 1 to 5. It's here on record, filed on 13/11.
Yes, Your Lordship. I'm actually appearing on behalf of another government advocate, so I was not aware, Your Lordship. I apologize.
Okay, affidavit is already there here in this case. Have you received?
Yes.
Yes. So here also only respondent 6, 3 weeks time to file their affidavit.
Item 21.
May I please, Lordship? May I please, Lordship?
Yes.
Lordship, I'm appearing for the petitioner's Lordship.
Okay. Yes, affidavit in opposition by state as well as CGC not yet filed.
Yes, Lord.
Learned Counsel for the petitioner, Mr. Such and Such, present. Stop. How much time?
3 weeks, my Lord.
The learned government advocate, MS Such and Such, and learned CGC have prayed for further 3 weeks' time to file their affidavit in oppositions. Stop. Prayer is allowed. Please stop the 3 weeks.
Humbly obliged.
Orders. Item 22.
Your Lordship's indulgence,
Yes.
making a mention, my Lord. Due to some personal difficulties, my senior has requested me to adjourn this matter after a week.
After a week?
Yes, my Lord.
Lord Learned Counsel, MS Such and Such, who makes a mention on behalf of the leading counsel. What's his name?
Mr. Elias
Mr.
Denchuma,
Such and Such, to list the
senior
matter
advocate.
after 1 week as the leading counsel has some difficulties today. So accordingly, list the matter after 1 week. So Learned Counsel for the respondent number. So respondent is Mr. Such and Such is present. So please after 1 week.
Obliged.
Item 23.
Yes, what is this?
Yes, Lordship, we have recently filed a new interlocutory application, but it has not been listed yet. So if that new application can be listed with this matter on Thursday.
Okay, you have filed for?
Impletement of the applicant
For
hearing,
implement,
yes.
okay. Heard learned counsel for the petitioner, MS and such, who submits that a new IA has been filed before this court, praying for implement
Of the applicant hearing.
of the applicant hearing stop. However, the same has not been listed before the court today, and she therefore prays that the IA may be listed along with the main petition. When?
On Thursday, Lordship.
On Thursday?
Yes.
Okay, on Thursday. Learned counsel for the respondents, you are appearing for? Mr. Malhotra, yeah. Learned counsel for the respondents.
They are the writ petitioners, Mr. Malhotra.
Oh, okay, okay. So you are for
We are the intervener.
Oh, the intervener. Don't say petitioner, okay, in the beginning. Learned counsel for the intervener. So, learned counsel for the petitioner, Mr. A. Malhotra, and the learned government advocate, and such and such, have no objections. Accordingly, list IA along with the main petition on Thursday. Give the date. Yes.
Give the light.
Item 18 for admission.
Yes.
May I please, Your Lordship? My Lord, the petitioners herein are lecturers under the government higher secondary schools. They were lecturers. Earlier, they were appointed as on contract basis, and then subsequently, after completing 5 years of continuous service, they were regularized into the said post. Now they were claiming for counting of their contractual
Past
period,
service.
past service, the entire full period for the purpose of placement to senior grade. But by the impugned order, my Lord, they were denied the same, and the state respondents had earlier stated they can count only 1/3. And that impugned order was also under challenge in other case, which was already disposed of by this coordinate bench. And that is in...
You have annexed?
Yes, my Lord. This is number 59, my Lord. The referred judgment, the petitioners were middle school teachers, and the present petitioners were higher secondary lecturers. This, my Lord, WPC number 85 of 2024. Have you got it? Page number 59.
WPC 85, yes.
This was disposed on
13/5.
13/5/2025, my Lord.
Just take us to the operative portion.
If I may take a lordship from para 6, page number 65, for better appreciation of the controversy, my Lord. From para 6, my Lord.
Para 6.
Page number 65.
Yes.
The issue to be decided is as to whether the rules of 2020 and the OM dated 22/1/2021 can be applied to the petitioners to enable them to count their past service rendered on contract basis for upward movement to the senior grade middle school teachers. The respondents, through the notification dated 19/7/2013, issued in exercise conferred by the provisor to Article 309 of the Constitution, had permitted counting of 8 years of service, either rendered on ad hoc basis or on deficit basis without any break, and which is continued by regularization for getting the benefit of senior grade pay. Thereafter, corrigendum dated 2/7/14, employees who had earlier rendered service under the CSS came to be included to get such benefit. It may be noticed that even the corrigendum was issued in exercise of the powers conferred by proviso to Article 309 of the Constitution. The rules of 2020 per se does not appear to debar the petitioners from counting their past service for movement to the senior grade pay scale, since the same is made effective from the date of its publication in the Gazette, that is 29/5/2020. You also may kindly notice the date of publication of these rules of 2020, that is 29/5/2020.
29/5.
Yes, my Lord. And my Lord, at this stage, these rules of 2020 provides that only 1/3 can be counted according to these rules. And
what rules is this? Rules of 2020?
Counting of past service rules 2020. This is the rules, is counting of past service rules.
Government employees counting of past service rules 2020. Okay.
It came into force with effect from 29/5/2020.
Did it?
And
what is this OM dated 22/1/21?
This is the impugn, my Lord. It made retrospective effect.
Oh.
It amended the main rules.
Okay, okay.
May I continue?
Yes.
The petitioners had been regularizing their service on 1/2/2018 And since the notification dated such and such permits a regular or confirmed government school teacher benefit of counting of past service rendered on such and such, the petitioners admittedly would be governed by notification of so and so. However, when the OM dated 22/1/2021 was issued, and which provided for the applicability of the rules of 2020 to everyone, irrespective of the date of the regularization, and also the necessity of being confirmed in service in order to avail for the benefit of counting of past service, the situation has changed. The petitioners therefore have been brought under the ambit of rules of 2020, and they have been allowed to count only 1/3 of their past service from the date they have been confirmed in service. However, the fact remains that the OM dated 22/1/2021 has been issued in the form of an executive instructions, and that the law in with regard is that the rules framed under Article 309 cannot be amended by way of executive order, circular, or instruction. The apex court in the case of Ajay Kumar Das, under the given facts and circumstances of that case, held that it is well settled that the statutory rules framed under Article 309 can be amended only by way of a rule or notification duly made under Article 309, and not otherwise. Whatever be the efficacy of the executive orders or circulars, statutory rules cannot be altered, amended by executive orders or circulars, nor can they replace the statutory rules. The rules made under 309 of the Constitution cannot be tinkered by the administrative instructions or circulars. Upon perusal of the affidavit in opposition filed by the state, the specific governments made with regard to OM dated such and such, being an executive instruction, and therefore cannot be override the earlier notification issued in exercise of the powers conferred by Article 309 of the Constitution, has not been rebutted and is silent. This court has also noticed that the respondents have also extended the benefit of notification to primary school teachers, middle school and high school teachers, who are similarly situated and were only regularized a little ahead of the present petitioners. Thus, upon due consideration of the materials available in the court, this court finds that the impugned OM dated 22/1/2021 is not sustainable, and the petitioners are also eligible to be granted the benefit of counting their entire past service to move to senior grade pay scale in terms of notification that such and such. Having come to such a finding, the office order 28/9/2022 is interfered with so far as it grants only 1/3 of the past service to the petitioners for counting to move to senior and selection grade. The respondents shall grant the petitioners the benefit as provided by the notification by issuing an appropriate order within a period of 8 weeks from the date of receipt of the certified copy of the order. The impugned communication dated such and such, as well as the OM dated 22/1/2021 are set aside. And my lord, thereafter, my lord, the state respondents, in compliance with this judgment order, had issued the compliance order. This was notification dated 1st August 2025. In compliance of the judgment order dated 13/5/2025 in WBC number 85/2024, and with the concurrence of DP and AR conveyed by such and such, as shown below, are hereby allowed counting of past services rendered at contract middle school teachers, followed by regularization as qualifying service for the purpose of non-functional upgradation to higher grade, that is senior selection grade scale, respectively as per notification of such and such. This is the compliance order of this referred judgment, my lord. Now, my lord, coming to the present case, we have been appointed on contract basis initially during the period between 2012 and 13. To be specific, my lord, I have make a chart at page number 9, para 6.
Page 9.
Page number 9, my lord, my writ petition, para 6.
Okay. Yes, regularized contracts and such regularized on 19/12/2018.
Yes, my lord.
2018.
And
confirmation on 24. And what are you impugning here? Where is the impugned order?
Page
here?
number 49.
49.
This is in reply in rejection of my representation, my lord. Letter dated 30/7/2024. Have you got it, my lord?
Yes, yes.
Annexure 10, page number 49. Communication dated 30th July 2024.
July 24.
This is the impugned letter, my lord. This is in reply to my representation, my lord. May I read?
Yes.
This is communication between the Under Secretary and the Directorate of School Education. With reference to the above, I am delighted to inform you that the application for counting of past contract service in full in respect of non-lecturer Government Higher Secondary School could not be considered as per the provision of the PNR Office Memorandum dated 22/1/2021, Parat 2I, and the provision of such and such.
22-1, which is already quashed, isn't
Yes,
it?
my lord, that has been quashed. So nothing remains, my lord. Now we should be made eligible to count the entire past contractual service.
How many petitioners are here?
Only 7 of them, my lord.
7 of them. And government as well affidavit.
No, my lord. This is in the after issuance of
Admission
notice, my
stage.
lord. I have pressed for disposal since the referred judgment was already complied.
Yes, you have gone through.
Yes,
So now this 22/1/21 has already been quashed.
Yes, Your Lordship.
And no appeal has been preferred.
Yes, Your Lordship.
So they are entitled, isn't it?
Yes, Your Lordship. I was also present in the case
Referred
annex,
judgment.
the referred judgment, Your Lordship.
Oh, okay.
Now my learned friend has fairly submits that this is clearly covered.
Yes.
It's very fortunate.
Let us see your prayer.
Yes, my lord.
Impugn letter whereby petitioners were denied rules of 2020 as far as the case of the entire full past service of the petitioners contract basis. So the entire contract service should be counted
Yes,
for
my lord.
qualifying service for the purpose of within terms of the okay, just go. Okay.
In the meanwhile, my lord, I'll also bring the notice for your lordship that in the referred judgment, the petitioners were middle school teachers, and the concerned relevant notification was issued on 2013. But for the present petitioners, they were higher secondary lecturers, and the concerned notification for granting that benefit was issued on 2012, which is in page number 36. Page number 36. This is notification dated 4th December 2012. Have you got it, my lord?
Yes, for December.
Pursuant to the decision of the Council of Ministers in its meeting held on 13/6/2012 and in exercise of the powers conferred by the proviso to Article 309 of the Constitution, the Governor of Mizoram is pleased to order that the eligible criteria for pay-up graduation of lecturer higher secondary school in the senior and selection grades shall be as follows with effect from 1/6/2012. Senior grade A, 8 years regular service in the entry grade in teaching profession shall be eligible to enjoy the senior grade. B, for the purpose of counting of 8 years regular service in the relevant grade, only continuous, uninterrupted service without any break rendered by a teacher in government higher secondary school, as the case may be, shall be taken into consideration. Now, in my case, my lord, I have been rendered uninterrupted continuous service under the government higher secondary school since my initial appointment, and that itself is proved by the subsequent regularization. Because under the state had formulated a regularization scheme, which is in page number 3030. I'm placing this because your lordship might not familiar with these state rules.
Yes.
Page number 3030, my lord. This is the Government of Mizoram Regularization of Contract Employees Scheme 2008. And if I may take a lordship to para 43, page 31, 43, which says that any person who has been continuously engaged on contract basis in the department for at least 5 years shall be eligible for regularization in the existing post against which he or she has been engaged, provided that such initial engagement had been done through the duly authorized DPC and he or she possesses the required and other qualification prescribed in the relevant rules. So, my lord, what I mean to say is that having been regularized under this scheme, that implies that we have been rendered uninterrupted and continuous service in the same grade.
So in the earlier petition, they were middle school teachers,
Yes, my
and
lord.
now here in this petition, you are higher secondary
Lecturers in the
lecturers.
higher secondary schools.
Okay. Heard Learned Counsel, Mr. Victor, no?
Yes.
Victor and such for the petitioners, and also Learned Government Advocate, MS, such and such for the respondents, state respondents. So the present writ petition has been filed by the petitioners who were initially appointed as lecturers in government higher secondary schools on contract basis during the period 2012 to 2013, and upon completion of continuous 5 years of service, they were regularized on 9/12/2018.
1912, yes.
On 19/12/2018, under the scheme, isn't it?
Yes, my lord.
Under the scheme as notified by the government of Mizoram, via notification dated 10th October 2008, which is annexure 2 in the writ petition. Stop. Para. The petitioners had made representations for placement to senior grade upon completion of continuous 8 years of service, counting from the date of their initial contract engagement, as granted to other similarly situated lecturers in terms of the notification dated 4/12/2012. Which one is this? 4/12/2012? Annexure?
Annexure 5, page number 36.
Yes. As granted to other similarly situated lecturers in terms of the notification number capital G dot 12017/2/2011 EDN dated 4th December 2012. Stop. However, the claims of the petitioners were rejected by the state respondents via impugned letters dated 30/7/2024 by referring to the impugned OM dated 22/1/2021 and the provisions of the Mizoram Government Employees Counting of Past Service Rules, Mizoram Government Employees Counting of Past Service Rules 2020, which provides for counting only 1/3 of the contract period. Stop. Para. The petitioners at this stage states that the impugned OM dated you have enclosed here also, no?
Yes, my lord.
22/1. Where is that? This 22/1/21.
Page number 57.
Page 57.
Annexure 13, page number 57.
Yes. The petitioners have stated that the impugned OM number A, capital A, dot 38020/2/2019 dated 22nd January 2021 was already quashed and set aside in WPC 85/2024. Stop. It is submitted by the Learned Counsel for the petitioner that by the order dated 13/5/2025 passed in WPC 85 of 2024, a coordinate bench of this court held that the impugned OM dated 22/1/2021 is not sustainable, and the petitioners therein were granted the benefit of counting their entire past service to move to the senior grade pay scale. Stop. It was held that the OM dated 22/1/2021 was issued in the form of an executive instruction, and that the law with regard the law is that the rules framed under Article 309 of the Constitution cannot be amended by way of executive orders, circulars, or instructions. Stop. The Learned Council has therefore prayed that a similar benefit may be given to the petitioners in the present case, as the facts and circumstances are similar, and this case is squarely covered by the judgment and order of this court in WPC 85 of 2024. Stop. Para. Learned Government Advocate, MS such and such, has fairly submitted that the petitioners herein, the facts and circumstances of the present case is similar to the case of the petitioners in WPC 85 of 2024, and similar order may be passed. Stop. In view of the above observations, this petition is allowed. Stop. The impugned letter dated 30/7/2024, whereby the petitioners were denied counting of their entire contractual service, is set aside and quashed. And the respondents are directed to grant the petitioners the benefit of counting their past contractual service, entire contractual service, as provided by
the notification dated
As per-
page number 36,
page 36.
4/12/2012. Or other ways, it can be also said that for placement to senior grade.
No, but we have to first the benefit as provided by the notification dated 4th December 2012. For upgradation, or what?
Yes, madam. Upgradation to senior.
Upgradation to senior grade. Stop. By the respondents shall issue appropriate order within a period of 2 months. Will do. 2 months, Learned Government Advocate, or 3 months.
Your Lordship, 3 months may be required.
Okay, within a period of 3 months from the date of receipt of a certified copy of this order. Stop. Any other? I think that should do.
Yes, madam.
Yes. Okay. With the above directions, this petition stands disposed.
Deeply obliged.
That's obliged, Your Lordship.